Receiving a deportation notice, officially known as a notice to appear, NTA, can be an overwhelming and frightening experience for any immigrant in the United States. It signals that the U.S. government believes you may be removable from the country and is initiating legal proceedings to determine your fate. However, it's crucial to understand that receiving this notice does not mean automatic deportation. It is the beginning of a legal process where you have the right to defend yourself, present evidence, and potentially remain in the country under certain legal protections. With proper steps, timely action, and competent legal help, many immigrants are able to halt or reverse the deportation process. This video outlines the top 10 steps to take after receiving a deportation notice, helping you or your loved ones respond intelligently and assertively to safeguard your rights and future. 1. Remain calm and do not panic. The first and most essential step is to remain calm. Panic can lead to poor decisions, like fleeing, ignoring the notice, or making uninformed statements to authorities. It's important to understand that a notice to appear is not the end of the road. It is the beginning of a process where you have rights. Recognize that many individuals who receive NTAs are not ultimately deported, and there are legal defenses and procedural protections you can pursue. Your mental clarity and emotional control in the early stages will allow you to take more effective and timely actions. Avoid making any drastic moves, like leaving your job, changing your address without notifying the court, or fleeing the area, which could harm your case or trigger further legal consequences. 2. Carefully review the notice to appear, NTA. After receiving the NTA, review the document thoroughly. It contains critical information such as your full name, alien registration number, the reasons the government believes you are removable, and the date and location of your first immigration court hearing. Mistakes in your name, country of origin, or legal status could be used as part of your defense. Make sure the charges listed are accurate. Sometimes immigrants are wrongly accused of visa overstays or other violations. Understanding exactly what the government is alleging allows you to prepare a targeted legal response. If anything is unclear, do not attempt to interpret it on your own. Take it immediately to a qualified immigration attorney. 3. Hire an experienced immigration attorney immediately. One of the most vital actions you can take is to consult with and hire an experienced immigration lawyer as soon as possible. Immigration law is complex, constantly evolving, and extremely difficult to navigate without legal expertise. A skilled attorney will review the NTA, assess the strengths and weaknesses of your case, help gather supporting evidence, and represent you during hearings. They may identify paths to relief such as asylum, cancellation of removal, adjustment of status, or even identify errors in the government's claims. If affordability is an issue, seek help from nonprofit legal aid groups, local bar associations, or pro bono clinics. Never rely on notarios or unlicensed consultants. Only licensed attorneys or DOJ-accredited representatives are authorized to provide legal representation. 4. Attend all immigration court hearings without fail. Failing to appear at your immigration court hearing is one of the gravest mistakes you can make. It can result in an automatic order of removal, often referred to as a removal in absentia. Once you receive your hearing date, if not included in the NTA, it will be sent by mail. Make it a top priority to attend on time, even if your case is still being prepared. Immigration courts do not take absence lightly, and judges may view non-appearance as a sign of disrespect or evasion. If you move, be sure to file a Form EOIR 33, change of address, within 5 days with the court, or you risk not receiving important notices. Treat every scheduled hearing with the same importance as a trial, because it is one. 5. Explore all forms of relief from removal. There are several legal avenues available to fight deportation, and an attorney can help determine which apply to your situation. Common forms of relief include asylum, if you fear persecution in your home country, cancellation of removal, for long-term residents with qualifying U.S. citizen family, adjustment of status, through family or employment sponsorship, waivers for criminal or immigration violations, and temporary protected status, TPS, or deferred action. For DACA recipients or those under special humanitarian programs, there may be updates that impact eligibility. Your defense must be crafted around one or more of these legal grounds. The earlier you begin preparing evidence for your chosen relief strategy, the better your chances of success. 6. Collect and organize supporting documentation. Your legal defense will be stronger if backed by thorough documentation. Depending on your claim, you may need to gather identity documents, country condition reports, medical records, police reports, affidavits, employment history, proof of continuous residence, tax returns, or family-related evidence such as marriage certificates or children's birth certificates. For asylum or withholding of removal claims, you'll need documentation of threats or violence in your home country. Be proactive and organized, create copies, translations, if necessary, and store everything securely. Your attorney will guide you on what is most useful, but don't delay in collecting it. 7. Avoid negative immigration or criminal conduct. Once you're in removal proceedings, any further violations, such as overstaying visas, working without authorization, or committing crimes, can seriously damage your case. Even minor offenses like driving without a license or failing to file taxes can be used to argue that you lack good moral character, which is essential for many types of immigration relief. Stay informed about the legal boundaries of your status and maintain impeccable behavior. Comply with all court orders, immigration check-ins, or supervision programs if applicable. Avoid interaction with law enforcement unless absolutely necessary and consult your attorney before making any travel or legal decisions. 8. Inform your family and prepare a safety plan. Receiving a deportation notice affects more than just the individual, it impacts families, particularly spouses, children, or other dependents. It's essential to inform your loved ones about your situation and prepare a safety plan. This may include assigning legal guardianship for children, organizing important documents, passports, birth certificates, etc., preparing emergency funds, and identifying someone who can communicate with your attorney if you're detained. Educating your family about their own rights, including the right to remain silent and the right to an attorney, can also provide protection in case of surprise encounters with immigration authorities. 9. Monitor case status and stay updated. Immigration cases can take months or even years to resolve, and delays or changes in case status are common. You must stay vigilant and updated. Use the EOIR hotline, 1-800-898-7180, or the online portal to check hearing dates and court decisions. Sign up for case alerts if possible. Your lawyer should keep you informed, but you are ultimately responsible for knowing your schedule and obligations. In addition, stay updated on changes in immigration policy. Executive orders, court rulings, or legislative reforms can affect eligibility for relief. Being informed allows you to act quickly if new opportunities arise. 10. Consider voluntary departure as a last resort. If all legal options have been exhausted and it appears that removal is inevitable, your attorney may advise requesting voluntary departure rather than forced deportation. Voluntary departure allows you to leave the U.S. on your own terms, typically within a set period, and avoids the legal penalties associated with being forcibly removed. This option can protect your ability to return legally in the future and prevent a multi-year bar on re-entry. While it's not an easy decision, it may be the most strategic one in certain cases, particularly if you have the option to adjust status later or apply through consular processing from abroad. Receiving a deportation notice is one of the most intimidating legal challenges an immigrant can face, but it does not mean all hope is lost. The removal process is legal in nature, and with the right response, it is often possible to remain in the U.S. or at least exit under better terms. The steps outlined above, from reviewing your NTA to hiring a qualified attorney, gathering evidence, and exploring all relief options, are essential to navigating this process successfully. Time is of the essence. Delays can reduce your options, while informed and timely action can empower your defense. Whether you seek asylum, cancellation of removal, or another pathway, your ability to act decisively could make all the difference. Remember, you are not alone. There are legal resources, advocacy groups, and communities ready to support you in your fight to stay.